Good evening. You're watching Access to Justice, and I'm attorney Delia Parker Mims. Today, we're going to do a continuation of what you might have been watching, the manifestation process. But we're going to continue and call this the manifestation process part 2. Because this is such an important meeting that you may have with your child, whether they be special education or 504, that we thought it was important to revisit what we outlined in our first meeting that we had with Dr. Morgan and kind of slow it down so that we could help parents have a more detailed understanding of what to do if they're ever giving a notice that their child is facing disciplinary consequences. Well, good afternoon, Dr. Morgan.
Oh, Ms. Parker Mims, it's very good to see you. Thank you for inviting me.
Well, of course. I mean, you are our resident expert on special education in 504. We started off this summer talking about that, and we kind of took a hiatus, but we're going to come back and give the audience a more detailed and thorough look as to what parents can do. And we kind of didn't get to go in there that a lot the first time around. I probably did not give you enough time to outline that, but we're going to rectify that. So if we remind our audience, we're the parent, and we received a notice that our special education or our 504 child is now facing disciplinary consequences that could be 10 or more days out of school. Okay. What do you do?
Well, as a parent, first and foremost, don't panic too much, but this is a very serious meeting that is being proposed by the school, obviously. So if you keep all of your documents that you receive from the schools in a nearby handy place, settle down, put those documents out, and you want to look for one that's called Procedural Safeguards, or you would like to look for another document that's called the Guide to the ARD Process. And manifestation determination meetings are described very clearly in layman's terms in those two documents. Another piece that you would like to have is the student's individualized educational program. And it's where you've been in a meeting and decisions were made between the school, the student, and the family on approaches in case behavioral concerns or disciplinary concerns show up. So you want to get that and make sure that when you visit with the school, you can identify those things that were to occur for your child happened, and if they didn't, then that opens the door for yet another conversation.
Okay, let's go with what you just talked about. And parents who have children who are either special education or 504 understand that. But let's give a brief description of what the special education is, the 504, the differences, and what documents they should already have because their child is already in that program.
All right. I'll speak first from the special education perspective. And special education is a service that is provided in every public school in the country. And federal government provides that initial law or guidance in the IDEA, which is Individuals with Disabilities Education Act, which was most recently reauthorized in 2004. And that document is the key piece of information that a parent needs, and you can Google it. I'll just put in IDEA 2004 and you can find the information that you want. Another document I mentioned earlier, which is the document Procedural Safeguards, and it's developed by the Texas Education Agency, TEA, and it also has all of those pieces of information specific to all types of meetings that can occur for a student in special education, as well as manifestation meetings. And of course, the ARD Guide document, also developed by the Texas Education Agency. Those are special education governance documents that schools and charter schools even need to address. The other part that you asked me to discuss is Section 504, which falls under the Rehabilitation Act. And Section 504 also addresses individuals with disabilities that typically are not eligible for services and supports under special education. Like special ed, Section 504 is also a federal piece, that schools are responsible for addressing. And it covers myriad of disabilities, from being obese to a recovering drug addict to dyslexia. So, I mean, the menu is varied. The information that supports Section 504 comes directly from the federal government. TEA allows districts to develop their own procedures on how Section 504 will be implemented.
Okay, so your first piece of advice to a parent in that situation is start keeping your documents. Once your child is either put in the special education or the 504,
correct,
they will be handed those procedural safeguards, or is that something they'll have to get offline?
Either way, the school is responsible. Once a student is identified for special ed, the school is responsible for disseminating those two pieces, the procedural safeguards and the art guide document, before they have their first meeting. In Section 504, those pieces of paperwork that are important will be developed and provided to the parent at the meeting.
Okay, so I've got the notice, I've gotten my documents, as you've advised us to do. What do we do next?
Like I said, review your documents. You may want to contact someone who's familiar with special education or Section 504 that isn't involved with you personally as a parent or involved with the school. So that's someone who's independent, a neutral person. And get with them and just kind of talk through where you are as a parent with all of this information that you have before you and what this means. But another very important thing is to get a little bit of input from your student. What has happened and what is their version of it, so that you're not blindsided when you sit down at the table with all the other stakeholders in this most important meeting. So reviewing those documents.
Well, let's do a specific scenario.
All right.
Or we'll make up one.
Okay.
And a student has, they're in 504, and they're ADHD as well. They're getting constantly being sent to ISS because they're moving around. So that has been adding up. But then they've done something, let's say they got into they drew a picture of something that was considered threatening. And the school then decides that they want to have a manifestation hearing to determine if that child should be expelled from school. What is the parent's response there?
Okay, hopefully the parent has received a copy of this artwork that the student has drawn, and obviously talk to their student to get their take on what this artwork represents and why it was developed. To again look at your child's Section 504 plan and what were some strategies that should have been implemented by the school to maybe have prevented the student from having that much time to make a drawing that was alarming. So when you get to your meeting with the information that you have, the picture, the conversation with your child's accommodation plan that identifies those strategies the school will employ, then that conversation is, did the school fail the student by not following that plan, but they still want to significantly consequence him or her for drawing a picture. So you need to have a reflection of what led up to the drawing of the picture, and I guess an adult in the environment looking at it and having a different impression about it.
And we're talking about the manifestation here. We want to make it clear at this point, because they are in special education or because they're in 504, they're getting added protections before the school can take disciplinary actions. Is that true?
To a degree, a school can take disciplinary actions that are within the Student Code of Conduct and that are within the student's behavior improvement plan and strategies or accommodations for that student in regard to specific types of behavior. So, yes, the school can impose consequences, disciplinary consequences, but it needs to be within all of the supports that have been identified through the accommodation plan, through the student code of conduct, and what was it that the school did or didn't do, and was that infraction related directly related to that student's disability.
Okay.
So those are some of the major discussion pieces on the table.
All right, so let's say the school wants to do a consequence that takes the child out of their regular academic setting and will last for more than 10 days. What has triggered at this point?
Well, probably leading toward an adversarial relationship between the school and the family. So that's where you start dissecting that accommodation plan. Has the instructor, have all of the people who work with the student been trained on that plan? To know when this happens, you do this. And when this happens, you do this. Did those things occur? Well, first of all, is there something like that? You're going to back up. Do you have that?
Do they have an accommodation plan?
Yes. Do you have a plan that
helps?
addresses behavior and expectations for the student? And what are those things that we're going to do? Should the student be engaged in structured activities, or is the student responsible for taking care of his or her own learning and learning activities that go with them, which probably led to the drawing? Who knows? Just speculating.
Okay.
So that's the centerpiece of the conversation. And then the school needs to be able to provide evidence to the parent that, yes, we have this plan, yes, these people have been trained, and then they're going to give you a document that shows which people have been trained. And those people should say, yes, I did this, and I did this, and then the student responded in this way. So if those things, if one, there's no training for the staff on the plan, that's a problem. Two, if the person in charge of the classroom, the adult in charge, didn't follow the plan or try to provide some structure for students who appear to need a little more guidance from the adults, then that could be a problem as well. And then that main piece is what happened with the student, despite the plan, despite the training, despite implementing all of that. Is it a characteristic common to that behavior that will cause that child? One, he has to be eligible for the service, and these things state what she will do because of this disability, and this is what the school will do to help her be successful. So if that behavior that occurred is a result of the disability, then the conversation is the school probably can't make that placement.
Okay. Is that where we get the term manifestation? If the conduct was a manifestation of the disability,
correct,
then you can't punish a child for behaving according to their disability. You're punishing them for being disabled.
It would appear so. You are correct. And yes, that is where the term comes from, manifestation determination, because the stakeholders around the table are trying to determine if the action that occurred manifested because the child has this disability.
Okay. Now, you mentioned quite a few things. They're going to be at the hearing. They're going to want to go through the document to ensure the school did what was required of them to do pursuant to the accommodations. Is there anything else that you would be looking at if you were in a manifestation hearing, other than whether or not the action was a manifestation of the disability or not?
I would encourage the committee to look at the plan that had been developed, and did it actually address the needs of the student, if it was strong enough to address the needs of the student. So that would be a part of that discussion. If you find that the school hasn't done its part, then the school needs to go back and evaluate the strength of the behavior intervention plan in relation to the needs of the student in a particular classroom or all classrooms or wherever the student is during the school day. You need to have some input as to whether other evaluation is needed. You know, are we missing something on taking care of the needs of the student? And so one of those pieces of evaluation or assessment would be a piece called Functional Behavior Assessment, an FBA. If one is not in place, then it would be prudent for the school to offer to do that or for the parent to ask the school to do that.
A functional behavior
assessment,
okay.
an FBA. And
would you ask that before they came to a decision as to consequences?
I think that the recommendation to conduct one or the request of the parent to conduct that FBA would be based on conversations. What's going on in that conversation? So there isn't a particular time in the meeting that you would do that. And I think as you listen to what's happening and it appears that that behavior plan is not strong enough, then maybe we need to find out what is it about this behavior that is feeding that child. What is it? What is the function of that behavior and what is for the outcome? How is that of value to the student?
Now, is all of this triggered because of the 10 or more day consequence that they want to enact?
The FBA?
No, the manifestation hearing and then the ensuing different things that you would ask for.
For students with disabilities, when you're looking at removing them from their typical instructional setting for more than 10 days, then yes, that triggers the manifestation determination. And that was a part of the reauthorization of IDEA in 2004, was to make that a little more clear. And it's a piece that the federal government, the Texas education agencies, and schools have been struggling with to make it a little more understandable and workable.
Well, let's try to break it down as much as we can. So what I'm hearing you saying is parents will need to listen to see if something that they want to enact would be more than 10 days. They need to know at that point that would trigger a hearing such as that, a manifestation hearing. And then the two things I believe you were describing is, one, within the process of that hearing, they'll determine if the behavior of the student was a manifestation of his disability, then that would trigger some issues with them moving forward with their disciplinary choices. And the other thing I believe you were describing is, did the school do its part? Is something else they would be looking for in that hearing. Is that correct?
That's correct, absolutely. And it is probably a best practice for the parent to work with someone who's familiar with these processes, to sit with him or her, to help them get through, and maybe even come to the meeting. I suspect oftentimes as a parent, knowing that your child has not behaved in a school setting the way, we've trained them when we send them off to school, you do this, this, and that, and somehow that kind of slips up, and it could be because of their disability that happens. But you're caught in an interesting place because you want to advocate for your child the best way possible and be armed with enough information to do that, but you're also still kind of entwined with that parent-child relationship that causes you to think with a different side of your brain or in your heart more than maybe you're prepared to do alone in that meeting. So it would be good to have an advocate with you. And it's not to say that the advocate is coming in an adversarial way against the school, but it's basically to help the parent process all of the discussion that's going on and, move them through point A, B, and C,
right,
so you can get to a good decision for the student.
Well, you mentioned earlier, you said if that were to happen, it would trigger an adversarial relationship with the school. And so what you're describing now is basically a situation where people are told, don't represent yourself because you're in the courtroom being very emotional about the situation. And of course, as parents, we know that that's certainly going to come up when you're in the adversarial setting. And then you mentioned you have the parent relationship. You're kind of mad at your child for what they're doing, but you kind of understand some of their reasoning behind it, so you're torn. And then it's a little bit, makes it a little cloudy to go through all of the points that you were discussing, like yourself. Now, you were we mentioned this on the last show, a executive in special education for several years in one of the Metroplex areas. So you're very familiar with those situations. Can you describe how those meetings, how they go, and maybe the tone and the temperament and what happens in an adversarial or manifestation hearing?
Well, there have been several scenarios. Some are very positive and supportive, and the team can come up with a good solution for the student. In those situations where the family is just very frustrated with the process, maybe this is not the first time that they've sat down for a meeting like this, and they feel hopeless, and so a lot of anger and distrust may occur during the dialogue.
Who would be in that meeting?
The people in that meeting should be a campus administrator, hopefully the principal, who is reasonably familiar with, if not very familiar with, the student, parents, anyone that the parent would like to bring who can help facilitate the movement of the meeting. Sometimes the student, depending on his or her age and the discussions that may take place, a general education teacher and a special education teacher. But the most important person who should be sitting at that table is the licensed specialist in school psychology, the LSSP.
Why do you say that?
Well, one, that individual will be very familiar with the evaluation instruments that were used to help identify a student with a disability. If it's a Section 504 student, physician may have provided some documentation about this child's suspected disability, and the LSSP is going to be very familiar with that. Any outside services that occur for that student in the area of counseling or medication therapies or what have you, the LSSP is going to be very familiar with those counseling strategies, and he or she is also going to be very familiar with many of the medications, if medication is involved at any point.
Does every school have that type of resource person?
If they do not have them hired as a part of their school staff, they should be able to contract with LSSPs to provide the expertise that a committee would need to make those decisions, and subsequently any services that that student might require.
Can a parent request that one be present?
Yes. Yes, absolutely.
And then at that point, will it be the schools, their responsibility to do that?
Yes.
So then they could find one district-wide that is available that could go through.
And hopefully would be familiar with that person, with that child in some instance, having conducted the evaluation for them, having been a part of that initial 504 or special education meeting or what have you.
Okay. You mentioned a lot about having an advocate, and we kind of talked about the emotional aspect that the parent is really going to be involved, and the very detailed nature of this type of hearing, going through the incident itself, going through the documents that you mentioned, knowing what rights the student has, and then going through the accommodations or the individual education plan, synthesizing through all of that information, and then trying to come up with a workable plan, because ultimately, hopefully all the stakeholders are interested in creating a plan, not just punishing, but in creating a plan that helps the student. So it seems like an advocate would be able to be removed emotionally from the process and have some type of understanding. Now, an advocate doesn't necessarily have to be a lawyer, is that correct?
That is correct.
Okay. who can be an advocate, and how would anyone find an advocate that would be able to help them navigate that process?
Oh, okay. Well, there is a group in the state of Texas called Partners Resource Network, and that would be the first place to start. And remember earlier when I mentioned the the procedural safeguards, information about the Parent Resource Network is provided on there. So if the parent wants to contact someone other than district personnel, they can certainly contact that resource group, and they have lots of tools and information available to help walk parents through, and may even send someone to sit with the parent in the meeting.
Is that a nonprofit, or is it simply a resource of stakeholders who are interested in that process?
It's a group of stakeholders who are interested in improving parent and school relationships, specifically among children with disabilities or families.
And a lot of times those type of agencies, they'll speak with the parent on the phone, may not even charge before that happens. I will have to plug in and say that we do this at Parker Legal Center. We provide that type of advocacy, whether it be with an attorney or with a non-attorney that will go in and help talk with the school, be a part of the manifestation hearing, and help bring the parent through that process. Now we're winding down. We have 2 minutes left, so I'm going to give you a time to make a statement or clear up anything that you would like the audience to know that would help them. Because at Access to Justice, we try to expand knowledge and opportunity and break down barriers.
Well, very good. Thank you, Ms. Parker Mims. Actually, I believe that if you have that resource available for families, maybe even inviting parents to come into your facility for 2-hour training so they can understand the documents that they have, identify what they need to bring, and then we could work together to identify families through churches and schools and resources, and have some online information. So I think that your center could certainly be of value to families in your viewing area.
And you have definitely been a resource that we've used at Parker Legal Center to go in and actually talk about getting more specific information about how to write behavior improvement plans, what should go into accommodations, or what should go into individual education programs with all of the years of training that you've had. I'm going to take the final statement since we're about to conclude with the audience. And I just want to remind everyone that every child has a right to a free and appropriate education, regardless of what their situation is or they find themselves. And if you are the parent of a special needs or a 504 student, it's important for you to make sure you understand what those rights are. There are advocates out there, such as myself, as well as Dr. Morgan, and there's also other networks available for you to access to get information to do that. If you want to continue this conversation, you can log on to my blog, which is Access, the number 2 Justice blog at WordPress.com. Dr. Morgan has an article published on it this month regarding the manifestation process, which will go into more steps if you wanted to print it and you have questions regarding that. So that's a great way to look at it. For Access to Justice, I'm Delia Parker Mims, and thank you for watching.